It's fundamental that once we incorporate a company, that company is a separate legal person, capable of entering contracts, committing torts, and even committing crimes. Some crimes a corporation can't practically commit. A common example is bigamy. Corporations can't marry once, let alone twice. What about torts and crimes which require states of mind, such as malice or dishonesty? In this case, Ridley was a shonky insurance agent whose job was to sign customers up to insurance policies. He worked for Producers and Citizens Cooperative Assurance during the 1920s, but was sacked for misappropriating company money. He then found a similar job with Colonial Mutual. His contract with Colonial Mutual included a clause that he would not, in any circumstances whatsoever, use language or write anything respecting any person or institution which may have the effect of reflecting on the character, integrity, or conduct of such person or institution, or which may tend to bring the same into disrepute or discredit. Ridley, however, had no intention of playing nice. He went around South Australia telling potential customers who already had policies with Producers and Citizens that Producers and Citizens was financially unstable and in danger of insolvency, and they should transfer their policies to Colonial Mutual. Producers and Citizens sued, and they recovered damages from Ridley personally. But the question was whether Colonial Mutual could potentially also be liable. The challenge was that slander was required to be malicious. Can a company actually have the state of mind of malice? Justice Dixon said Ridley was acting in right of the company with its authority. It follows that the company, in confiding to his judgment, within the limits of relevance and of reasonableness, the choice of inducement and arguments, authorised him, on its behalf, to address to prospective proponents such observations as appeared to him appropriate. The undertaking contained in his contract not to disparage other institutions is not a limitation of his authority, but a promise as to the manner of its exercise. In other words, because the company had appointed Ridley to act on its behalf, any malice on Ridley's part could be imputed to the company, and so the company was liable. From this case, we learn that corporations can be guilty of crimes or torts requiring a state of mind like malice or dishonesty if the corporation has appointed an agent who holds that state of mind.